Hello friends. In the last episode, I discussed on several case laws on the point of maintenance claim by married wife. I got huge response in my last video, and so I decided to do this video again with further more interesting and more rare case laws on domestic violence and maintenance claim by married wife. I think this video will be very much helpful for the newcomers in the profession as well as the litigants parties. Now, question number 1. Whether a live-in partner can seek maintenance under the Domestic Violence Act. Not married, but they are only residing in a live-in relationship, which is most common nowadays. What is the provision? Supreme Court in Lalita Tappu case decided that the petitioner in the case would have a remedy to seek maintenance under the Act. The Act means Domestic Violence Act, despite the fact that she is not the legally wedded wife and thus not obliged to be maintained under Section 125 of the CRPC. So, if a lady is residing in a live-in relationship with her male partner without any marriage, that lady is entitled to claim maintenance from her male partner under the provisions of Protection of Women from Domestic Violence Act 2005, but she is not entitled to claim any maintenance under Section 125 of the CRPC. Supreme Court is very much clear on this point. Another question: whether a complaint can be filed under Domestic Violence Act only against an adult male person and not against the husband's female relatives, that is mother-in-law and sister-in-law. Judgment is on your screen. The Supreme Court resolved the question by ruling that the provision to Section 2Q that doesn't exclude female relatives of the husband or male partner from the scope of a complaint that can be submitted under the provisions of Domestic Violence Act. As a result, complaints can be filed not only against the adult male person but also against adult female relative of the husband. So, in a case of domestic violence, in a complaint filed under the provisions of domestic violence, complaint can be filed against the male members of the husband's family as well as against the adult female members of the husband's family. The next question is on your screen. Whether brother-in-law comes under the definition of respondent under Section 2Q of the DV Act. Brother-in-law. Supreme Court rejected the appellant's allegation that Section 2Q of the Protection of Women from Domestic Violence Act defines respondent as any adult male individual who is or has been in a domestic relationship with a partner against whom the remedy is sought. The Supreme Court drafted a domestic connection between the woman and her brother-in-law, stating that the brother-in-law and the woman are a joint family. So, the question was whether brother-in-law of the complainant, aggrieved person, female complainant, can be filed, the complaint can be filed against her brother-in-law, and Supreme Court held that a domestic connection between the woman and her brother-in-law, stating that the brother-in-law and the woman are a joint family. So, complaint against brother-in-law is well maintainable. The next, maintainability of Dvks. Here, Supreme Court opined that mere vague allegation is not sufficient to bring the case within Domestic Violence Act. In our practice life, many times we find that the complaints are basically stereotype and vague allegation. So, mere vague allegation is not sufficient to bring the case within Domestic Violence Act. In another case, Calcutta High Court held that in absence of any evidence or materials on record, the grant of compensation. Here the Calcutta High Court discussed about the point of compensation in Domestic Violence Act case. That in absence of any evidence or materials on record, the grant of compensation cannot be justified. Section 22 of the Protection of Women from Domestic Violence Act 2005 speaks about the compensation and damages for the injuries, including mental torture and emotional distress caused by the acts of domestic violence committed by the respondent. So, in the matter of claim of compensation, there should be material on record to show that there was injury, including mental torture and emotional distress caused by the act of domestic violence committed by the respondent. Otherwise, no compensation can be allowed. Now, another question, whether DV case is maintainable against parents-in-law. Madhya Pradesh High Court held that if the wife and husband leaves the share households to establish their own household, the domestic relationship comes to an end, and in respect of parents, and therefore complaint under DV Act cannot be maintained against them. The domestic relationship must be there between the aggrieved person and the respondent to invoke domestic relationship, Domestic Violence Act. So here, what is the main point here? When husband and wife get detached from the parents of the husband lives in one place and the husband wife lives in another place, whether in that case a domestic violence case can be instituted against that parents-in-law who are residing separately. Madhya Pradesh High Court is very much clear on this point, stating that when they have started residing separately, there is an end of domestic relationship. So, in such cases, Domestic Violence Act case cannot be instituted against the parent-in-laws. Bombay High Court decides that a divorcee is not entitled to the benefits of Domestic Violence Act. The question is whether a divorced woman can file complaint under Domestic Violence Act. Bombay High Court is very much clear on this point, stating that a divorcee is not entitled to the benefits of the Domestic Violence Act. In another case, on the point of shared residence, the Supreme Court held that under DV Act, the property of husband's property, which was not a joint family property, did not come within the meaning of shared household. I am reading again. Held that under Dvks, the property of husband's property, which was not a joint family property, did not come within the meaning of shared household. So, definition or explanation of the shared residence has been cleared by the Supreme Court in S.R. Batra case, that the property of husbands, which was not a joint family property, did not come. It must be a joint family property. Did not come within the meaning of shared household. Now, Madras High Court held that women members of the family cannot be commanded to be removed from the shared household under the pretense of granting an order under section 19(1)(b) of the Domestic Violence Act. Very important judgment. Protection order. What is that? Women members of the family cannot be commanded to be removed from the shared household. Women members cannot be removed from the shared household under the pretense of granting an order under section 19(1)(b) of the Domestic Violence Act, held by Madras High Court. Now, Bombay High Court held that even though a man is the sole owner of a house, he has no right to be aggressive against his wife or the lady he lives with. And if the court notices any violence, he must be barred from visiting the residence. The husband or the male partner, though he is the sole owner of that property, he can be barred from visiting that residence if there is any evidence of violence. What is the purpose? Primarily to protect his wife and children from additional violence, any further violence and similar disagreement. If there is any dispute and difference, and based on the dispute and difference, there is some kind of violence, mental or physical torture or anything, shouting, screaming, anything. Though the husband is the sole owner of that property, he can be barred from entering that property in order to avoid further violence or any further incidents. So husband can be barred, but not female members. Now, in the question of live-in relationship, the Honorable Supreme Court ruled in this decision that not all live-in partners are marriage-like relationship. Guidelines for testing the concept of live-in relationships are here. The Supreme Court further stated that all live-in relationships are not marriage-like live-in relationship. Then what is the test to decide whether our live-in relationship is like a marriage-like relationship or not? On this point, Supreme Court gave some guidelines. What is that? Number one, duration of the relationship. How long they are residing in that live-in relationship. Number two, shared household pooling of resources and financial arrangements. How they are managing their household matters, whether they are sharing money or they are sharing jobs or they are sharing other things or not. Number three, domestic arrangements. How they are making their domestic arrangements in a family between husband and the wife. There are several domestic arrangements. In fact, in a family of husband and wife, both the parties naturally decides, I will do these sorts of things you will have to do these sorts of things like this. So, what is the domestic arrangements between the parties in live-in relationship? Number 4, sexual relationship children, whether they have any physical relationship and they have got any children or not. Number 5, socialization in public, whether they are attending various parties, various occasions, whether they are roaming about as husband and wife, though they are not husband and wife, but they are attending the society, they are meeting the society as if they are husband and wife. This question is also important. Number 6, intention. What is their intention? If their intention is, we will marry in future, right now let us reside in a live-in relationship and maintain a family, we will solemnize our marriage after 10 years and let us give a try for the 10 years. And in these 10 years, they have physical relationship, they got their children, they are sharing their household business, they are managing their household matters. All these will be considered. And the last one is conduct of the parties. Whether the parties, that is the male partner and the female partner, how they are conducting their behavior with each other. Friendship and husband-wife relationship are different. Though husband and wife is the best friendship relationship, but there is something else which is not present in a friendship relationship. Whether that particular things are present in this live-in relationship or not. If these are present or either of these are present, then that live-in relationship will be considered as a live-in relationship, and that lady will be entitled for all benefits for that live-in relationship. What are the benefits? I discussed earlier in this episode that in a live-in relationship, the female partner is entitled to claim maintenance under Domestic Violence Act, but she is not entitled to claim any maintenance under 125 CRPC. The next one, by Chhattisgarh High Court. Here, the Chhattisgarh High Court rejected the maintenance to wife if husband is able to prove that she was working and well qualified prior to marriage and she is well earning after marriage, and when she has filed under section 125 case under section 125 CRPC. Here the High Court also pointed out that the negligence or incompetency of family court to recognize the earning capacity of wife. So, Chhattisgarh High Court, Bilaspur bench, very clearly decided that maintenance to wife if husband is able to prove that she was working and well qualified prior to marriage, and prior to marriage she was earning, and after marriage she was also earning. So in such case, maintenance will not be allowed. The Chhattisgarh High Court further pointed out the negligence and incompetency of the family court to recognize the earning capacity of the wife. Sorry. So, while deciding such matters, not only the earning or the education will be considered, but the earning capacity of the wife to be considered. The complainant may not be earning a single penny, but She is a chartered accountant. So she has her own earning capacity. That earning capacity is also to be considered, even if she is not earning. So today's session is very short. I tried to put some very important and very vital case laws on the point of domestic violence, on different points of Domestic Violence Act like live-in relationship, shared households, etc. And I further pointed out some points, some case laws on the point of maintenance. In the next episode, I will discuss entirely on the landmark Supreme Court case of Rajneesh Neha. The next episode will be completely on Rajneesh Neha case. Till then, goodbye, stay blessed.